Okay, greetings everybody, and welcome, a warm welcome to our inaugural co-organized ADR IP seminar. It is wonderful to be able to see all of you here. Different time zones, some very early, some very late. But I looked at the list and I was happy to see both old, familiar names and new ones. So from wherever you might be, welcome. We have a magnificent group of speakers over 3 continents, and I think we can have a very good discussion. What is the goal today? The goal is to have a roadmap to understand the best systems for IP dispute resolution. It may be litigation, but many times it may not be. Our job at the end of the day is to help innovators, creators, brand owners find the best solution to resolve their disputes efficiently, effectively, and justly. And we need to do so with a global mindset because supply chains are global, businesses are global, and intellectual property portfolios are global. And if nothing else, the global pandemic just reminds us of how interconnected we are. And we need to have a roadmap today. And I hope at the end of this session, we'll start seeing new ways in which we can think about dispute resolution in intellectual property. And I can assure you that we have marshaled the best possible team to do that with us today. I'm very pleased to recognize Heike Volgas, the head of the IP Dispute Resolution Center at WIPO ADR. It just shows their thought leadership in having an entire unit just devoted to alternative dispute resolution, mediation, and arbitration. Very pleased to recognize her. In a few moments, you'll hear from her, but I also want to recognize the Intellectual Property Office of Singapore. That's been a forerunner in not transforming the thinking from just being an IP office to really being an innovation driver, an innovation hub. And if you are available, they have a full week of IP events next week, culminating in the Global Forum for Intellectual Property. So I think maybe Sandy or Rina might talk more about it. I'll hand it over to them. So thank you all very much. I look forward personally to learning a lot about how to think about intellectual property and ADR internationally. So over to you, Heike. Thank you.
Thank you very much, Daryl. Good morning, good afternoon, good evening, wherever you are. Welcome to this online event also from my side. My name is Heike Volgast. I'm heading the IP dispute section at the WIPO Arbitration and Mediation Center in Geneva in Switzerland. And I'm participating today with my colleague Chiara Arconero, who we are going to meet in a couple of moments, and who has been the WIPO Center representative in Singapore for the past 3 years. Let me start by thanking really Daryl and Rina and the very efficient teams for putting together this program today, which really is the most recent in a long series of joint activities that we have been undertaking in the past, ever since we started collaborating with IPOS some 10 years ago by now. We're very happy to see so many participants joining us for this event today from Asia, from Europe, from the US, and I would like to thank all participants already now for the interest. The topic of today's event, as Daryl was just saying, thinking internationally about IP and ADR, really is our daily work here at the where we handle and administer international IP and technology disputes that parties have referred to, WIPO mediation, arbitration, or other forms of ADR. And before we move to the panel discussion, and I'm looking really forward to hearing all the speakers' views on this topic from different perspectives and angles, I would just like to share with you, by way of opening comments, a couple of developments that we have noted here at the center over the past years. There's first certainly a growing caseload that we note here at the center. We had in 2020 alone an increase of cases of some 24% in mediation and arbitration, which we believe really reflects a growing understanding by parties and understanding the options offered by the various forms of ADR to resolve their IP and technology disputes. Parties from Asia, Europe, and the US remain the main user groups in our cases, and disputes cover the entire spectrum of IP and technology. Second development that we note is a growing role of intellectual property offices in courts in promoting or even offering ADR services, especially mediation. And ever since we initiated collaborating with the Intellectual Property Office of Singapore, IPOS, some 10 years ago, which was our first collaboration in that sense, which initially started with trademark options, mediation options for trademark proceedings, and has expanded beyond that ever since. We now collaborate with IP and copyright offices in more than 40 countries, each of them designed to help parties in the different jurisdictions to understand and use ADR options. In some countries, such collaboration also concerns or relate to disputes pending before courts, such as, for example, or collaboration with some courts in Shanghai, under which some international IP cases have been referred to WIPO mediation recently. And the final comment, perhaps, on the development that we also note is a certain growing efficiency, as I would call it, of the ADR proceedings themselves, concerning time, concerning cost, concerning also increased settlement rates. And we certainly see a certain link with, at the same time, this move to the online conduct and filing of proceedings, as we all have over the past year. And that certainly is a longer term trend. And beyond the current situation, and the WIPO Center makes available certain tools to parties to facilitate that currently and also in the future. And my colleague Chiara is going to come back to these points in a minute. So I think with that, I really look forward to the discussion. I'm sure we will come back to some of these points I just raised from the speakers in various ways. So thanks again to IPOS and Professor Lim, and I'll hand over the floor to Rina now. Thank you.
Well, thank you very much for that, Heike. And Professor Darrell Lim, Ms. Heike Volgas, distinguished panelists, ladies and gentlemen, good morning, good afternoon, good evening. The Intellectual Property Office of Singapore, otherwise known as IPOS, is really honored to co-host this webinar entitled Thinking Internationally About IP and ADR, What Every Lawyer and Corporate Counsel Should Know, as an associated event of IP Week. And Darrell referred to IP Week, which is taking place next week. It is an annual event that IPOS host to bring together different fields of expertise across the globe to explore trending issues in the IP landscape. This year, the theme of IP Week is Ideas to Assets, Emerging Stronger with IP. So apart from dispute settlement, there will be sessions on IP financing, IP licensing, artificial intelligence, amongst others. And we welcome everyone to join us in IP Week. It will be mostly digital, so there's every opportunity for everyone to join us, and we welcome you on that. Alternative dispute resolution is really crucial in enabling customized dispute resolution. A dispute resolution option that's tailored to the dispute allows for optimal resolution of the same. And in many cases, it translates to costs and time savings, which thereby also increase access to justice. And we heard Heike just now mentioning about the growing efficiency in ADR proceedings. Earlier this year, Singapore released its national IP strategy known as the Singapore IP Strategy 2030 or SIPS 2030. It is our blueprint for the next 10 years, and I'm sure that it will come as no surprise that IP ADR is one of the prongs in our overall IP strategy, where we seek to promote Singapore as a choice venue for IP ADR. And we have made some progress over the years, but of course, there's room for improvement. The Singapore International Arbitration Centre, or SIAC, has been recognized as the second top arbitral institution in the world in the latest Queen Mary University of London White and Case 2021 arbitration survey. And I'm pleased to say that the SIAC has an international panel of IP specialist arbitrators, including one of our speakers today, Mr. David Perkins. In addition, the Singapore International Mediation Centre, or SIMC, has recently collaborated with WIPO in the management of IP and technology disputes. And we're very happy to host the WIPO Arbitration and Mediation Centre's Singapore office, the first outside the WIPO headquarters. As well, we have the Singapore International Commercial Court, or SICC, which has jurisdiction to hear in personam IP disputes. And the court boasts of international a justice of the Delaware Supreme Court, as well as Justice Lord Newburger of Abbotsbury, who was the former president of the UK Supreme Court, and Justice Robert French, the former Chief Justice of Australia, who has a special interest in IP. Based on a recent survey conducted by the Singapore International Dispute Resolution Academy, or SIDRA, hybrid dispute resolution mechanisms have the potential to reduce the perceived disadvantages of a standalone dispute resolution mechanism. And this is one area which can be looked into in our quest to enhance access to justice. And it's certainly timely to have that open conversation about the challenges at the intersection of IP and ADR on the international front. And we are very privileged to be able to partner the University of Illinois, Chicago, as well as the WIPO Arbitration and Mediation Center to discuss this important topic. And I want to thank Daryl for inviting IPOS to be a part of this discourse. And I'm really looking forward to the discussions on this issue. And it leaves me to wish everyone a very engaging and fruitful seminar. Thank you very much.
Thanks very much, Rina, and thanks, Heike, for those very inspiring remarks. We're going to transition in a moment to the panel discussion, but there's a question there for Heike in the Q&A. I'd suggest that if you have questions for either Rina or Heike, please either contact them directly. I'm sure they'll give you a full response then, or you can email us and we'll pass the message on. Yeah. So thank you, Heike. Thank you, Rina. We are going to invite the rest of the panel on. And all you need to do in this digital age, instead of stepping off the stage, is just to turn off your camera, and hope you'll stay to enjoy the discussion as well. Thank you.
Thank you, Daryl. Thank you. Thank you, Rina.
Thank you.
Thank you.
Well, I'm going to introduce them in the order that they appear. So Chiara Acunero is now back in Geneva, sunny Geneva, and she was previously in Singapore. So she's with the WIPO ADR Center. We have Judge Jim Holderman, former Chief Judge of the Northern District of Illinois. Now he is a mediator and arbitrator with JAMS. We have David Perkins, also mediator and arbitrator from JAMS, but Judge Holderman is here in Illinois, and David is in a in a place that was once part of the European Union. And we have Sandy as well. Is Sandy on stage? Well, okay. Well, we have Marco. Marco is the Chief Licensing Officer and Deputy IP Officer with ZTE, and we're very pleased that we can hear from Marco and also understand a little bit better what often happens behind the silk curtain in China. And we're just missing Sandy now. Is Sandy able to turn on her camera? Well, we'll introduce Sandy. Oh, there she is. Okay, hi, Sandy. How are you?
Okay, hi. Oops.
Well, Sandy is Senior Legal Counsel, Hearing and Mediation Department at the IP Office of Singapore, and has been very much involved in the work which you heard Rina describe in Singapore's initiatives, and particularly in ADR. So welcome, Sandy. So we'll start off with Chiara. Chiara will give us a broad overview, really from a multilateral perspective of what's going on in ADR. We'll have a quick time of Q&A. So if you have questions during Chiara's presentation, please put them in the Q&A box and Chiara can get to them. We might have a couple for her as well. And then we'll transition to Sandy. We'll do the same. If you have questions for Sandy, please don't wait until the Q&A. You can welcome to put them in the box ahead of time. And then we'll transition to a general time of discussion where David, Judge Holderman, Marco, Chiara, Sandy, and I will be talking about the intersection between ADR and IP more generally. So that's the plan for today. I think it's going to be interesting and it's going to be very informative. So Chiara, over to you.
Thank you very much, Daryl, and thank you everyone really for attending this session. It's really a privilege to participate in this webinar and to showcase the experience of the WIPO Arbitration and Mediation Center, where I work now as legal officer at the office in Geneva. But as Daryl and I already mentioned, I spent the last 3 years at the office in Singapore as representative, and that also gave me the opportunity to work very, very closely with IPOS. So the idea for the next few minutes is to present the experience of the WIPO Arbitration Mediation Center mediating and arbitrating intellectual property and technology disputes, and also to share some of the latest developments that we've seen over the years. So I will now share my PowerPoint. Now, I believe perhaps a very brief introduction. Most of you are very familiar with the word intellectual property organization, the WIPO, which is a specialized UN agency. So we're part of WIPO, and WIPO provides a number of intellectual property related services. Now, one of these services is also mediation, arbitration, and other forms of ADR to resolve intellectual property and technology disputes. And this really comes from the consideration that intellectual property disputes, technology disputes, have certain features which are very well served by procedures like ADR, like mediation, arbitration. So just to name a few, IP disputes are often very specific, so they require a certain expertise from the decision maker or the mediator. Very often IP disputes or technology disputes are cross-border ones, so they have an international dimension. Also, there is very often a very strong interest in confidentiality when it comes to IP and technology disputes, and also very often time is of the essence, and this is because the very fast-paced technology intellectual property industry. So at the WIPO Center, we really try to respond to these needs, providing this mediation and arbitration services. We focus on IP and technology cases, although we also see general commercial cases. And we, because we're part of the World Intellectual Property Organization, the WIPO Center is really unique in a number of ways. So first of all, we specialize in intellectual property and technology. So for example, we have a set of rules, mediation rules, arbitration rules, expert determination rules that contain certain provisions that were really thought for intellectual property disputes. For example, on confidentiality, on technical evidence. But also we have a certain expertise in terms of mediators, arbitrators that can be appointed in our cases. So we have a list, a database of over 2,000 experts in all the fields of intellectual property that can be selected by the parties as their mediators or arbitrators. And also, and this is a consideration which can be very helpful if you're ever involved in an international dispute. We are a neutral dispute resolution forum. So this means that we have no connection, no link whatsoever with any jurisdiction, any law, or institutional culture, or language of any country. And this is an advantage if you are involved in an international disputes, because there no party has any home court advantage. I was mentioning the neutrality that the WIPO Center can offer as a forum, which is very often an advantage when you're dealing with an international dispute. And this is another special feature that the WIPO Center has, together with this specialization in intellectual property and technology. Also, we have users from all over the world, so our services are being used globally. And in terms of fees, this very much depends on the case. We try to keep our fees as low and reduced as possible, and we also have a number of schemes. For example, we have a recent one for SMEs to facilitate access to mediation and arbitration, but really depending on the amount in dispute and a specific case. And this is something else that we do as an arbitration mediation provider. We also fix the fees of the mediators and arbitrators in consultation with the parties. So we always adjust our procedure and our rules to the specific case. Now, even before a case is filed with the WIPO Center, we also provide procedural assistance. So we provide information on ADR. So for example, if someone is involved in a dispute, we can give procedural advice on how to start a mediation process. But also we help parties drafting contract clauses or submission agreements. We do have various model clauses which also combine various ADR procedures like mediation, arbitration, as Rina was mentioning in the opening remarks, having a hybrid dispute resolution procedure, which, for example, combines mediation and arbitration, is something that we see being used very, very often and also very effective in practice. But in addition to the model clauses, we are also available to review certain clauses and also to tailor some clauses if there is any specific collaboration. So that's also something that we do. And of course, once we receive a case, we administer the case. So we make sure that the case is on track. We have a specific focus on containing time and cost. We facilitate conditions. We help parties negotiate the fees of the mediators, arbitrators. We also provide a number of online tools for example, video conferencing services, which have been used very often in the past couple of years. And I have to say, as Heike was mentioning, the experience so far has been very, very positive in terms of further containing time and cost, but also in terms of settlement rate. We've seen an increase also of the settlement rate over the last year, where most meetings were actually conducted online, and they're of course offered by WIPO. And then something else that we do, which is one of the crucial points in administering a mediation arbitration, we assist the parties in selecting a mediator and an arbitrator. And of course, it's very important, but even more in intellectual property disputes that can be particularly specific, having the right expertise, whether that's in technology or intellectual property or arbitration or mediation, is really crucial. So when we do that, we also try to involve the parties in the selection process as much as we can. We have this database of more than 2,000 experts where parties can select arbitrators, mediators, but we also give the parties an opportunity to give us some feedback on the type of mediators, arbitrators they require for the case. So they can be in terms of experience or expertise, but also in terms of geographical location or language. And then we really, based on this feedback, we propose candidates to the parties. But parties are involved really in every step of the way. And we've also come up with a checklist on the online conduct of mediation arbitration proceedings, which summarizes our experience in the past couple of years with online meetings. We also have very recently, actually since July this year, updated our rules, our mediation, arbitration, expert determination rules. As I was saying, they already contain some very IP-specific elements, such as for confidentiality, technical evidence, interim relief. But at the same time, the changes that we have included reflect a little bit our experience of the past year. So, for example, we now make express reference to electronic filings and also the possibility of having online meetings in our rules. And in general, these rules are also applicable and they're being used really for any type of commercial disputes. At the same time, one of the other advantages of mediation arbitration is that it is the parties' process, so that the parties are able to tailor the procedure to their needs. And that's something that is also reflected in our rules, in the sense that the rules have the purpose to structure the proceedings, to give parties guidance. But at the same time, they can also be modified by agreement with the parties and the mediator and arbitrator. We've also included some reference to the Singapore Mediation Convention in our mediation rules. And while it is true that our focus is international disputes, as we are a global neutral dispute resolution provider, we've also seen our rules being used for domestic disputes. Now, this is one procedure that we also administer that I wanted to show you because this has been used very often in the past years. For example, in cases of infringements, although not necessarily. We also give the parties the opportunity to unilaterally request WIPO mediation. And this is whenever there is no mediation agreement between the parties or where there is no agreement at all between the parties. So the typical case is that of an infringement. But it can also be used in the context of a court referrals. So this gives the opportunity to one party alone to unilaterally request for WIPO mediation. And as you can see, it's a one-page document, so it's very straightforward. Yes, I'm referring to slide number 6. Thank you. It's been challenging. I wanted to share a few words on the caseload of the WIPO Center and the specific types of cases that we see. Patent cases are still among the most common ones, but we've seen an increase in IT and software-related cases, as well as trademark cases. And also, sometimes we do see commercial cases where there are even no links to intellectual property. What I think is quite interesting is in terms of the source of cases, many cases, almost 50% are now non-contractual. And this is where, for example, the unilateral request for mediation is being used very, very often. But overall, most cases are international. Just a few words on the settlement rate. For mediation, that's 70%, but only the last year it actually increased to close to 80, so it was 78%, and this was hand in hand with an increased use of WIPO online tools. We also see a settlement rate of 33% in WIPO arbitration, and that's often the case if parties before had a mediation phase, and then during the arbitration they realized that there was some space for settlement, so they have the possibility to suspend the arbitration proceedings. And I also wanted to mention our collaboration with IPOS in Singapore, because it also summarizes very, very well some of the collaborations that we have with other intellectual property offices and some of the most recent areas of development. So the one with IPOS was our very first collaboration, and then we have developed together with the IP Office of Singapore a WIPO mediation option that can be used in the context of IPOS proceedings. And this is in various areas. So trademarks is one of those, and where we see most cases, but also in the area of patents, designs, geographical indications. And what we've done together with IPOS, we've also developed a panel of mediators who are based in Singapore. We also have a reduced set of fees, and then we also have expanded the collaboration to cover copyright disputes, and this was very recent. This was a couple of years ago, and more generally, and that's something that we do with other IP offices as well. We promote and we raise awareness of mediation and arbitration options, and this can take the form of mediators trainings, but also more general public ADR outreach events. Now, I think we're running out of time with some of the technical issues as well. But the last thing I wanted to mention is that we also tackle some specific sectors where we find that some tailored adjustments to our general framework can be useful. And one of these sectors is FRAND. So in the area of FRAND, we also have developed some really tailored model FRAND submission agreements that we have developed in collaboration with also other stakeholders, and we have developed and actually updated this year a guidance on all these options on FRAND, ADR, and the options offered by the center, and that's available of course on our website. There is reference on the slides as well, but basically we provide for mediation, arbitration options, and all these model agreements that you can use, and of course again they can also be reviewed, and then we can assist drafting those as well. So I hope I was able to share some of the experience, even without the slides or very small slides in this presentation. I don't know if we have any time left for questions, or if we should address them in the panel discussion.
Thanks, Chiara. I think we'll move on to Sandy's presentation, and then we'll pick up the questions later on. Sandy, it looks like now we have managed to figure out how to do this. you want to share your slides, or do you want me to do it? I'm happy to provide concierge service.
Could you please?
Okay. You can start speaking first.
Oh, okay. So good morning, good afternoon, good evening, everybody. My name is Sandy, and I'm from the Intellectual Property Office of Singapore, IPOS. I'm extremely privileged today to be part of this webinar. And for my part of the session, I will share with you some of Singapore's initiatives and experiences in the area of IP ADR. So am I going to get the slide, Daryl, or... Yes, the next slide, please, Daryl. Yes, so it's a bit small, but it's actually the overview of my slide. So I will touch on the different ADR options before looking at the suitability of ADR to resolve IP disputes. I will then introduce some of our local service providers and offerings before sharing some of the success stories. And last but certainly not least, I will share with you some highlights of our Singapore IP strategy for the next 10 years pertaining to IP ADR. Next, please. Next. Thank you. So we'll start with the dispute resolution spectrum because it is important to have an overview of the dispute resolution landscape before dwelling proper into the subject matter. Litigation is the default dispute resolution option or the conventional dispute resolution options. Other options are therefore called alternative dispute resolution options. In other words, there are many ways to resolve an IP dispute. It is important to understand the different ways to resolve an IP dispute as each dispute resolution option has its own advantages and disadvantages, which also explains why each particular option sits at a specific location on the dispute resolution spectrum, as you can see on the slide. So the key is to find the best way to resolve your IP dispute at hand. And this also means that actually, depending on the case, litigation may or may not be suitable. Therefore, it is crucial to set the stage to emphasize that we are not advocating that ADR or alternative dispute resolution is superior to litigation or conventional dispute resolution. But what we are saying is that we need to use the most suitable dispute resolution option to resolve the IP dispute at hand. Having said the above, since there is more familiarity with litigation in comparison to the rest of the dispute resolution options or ADR, there is therefore a need to raise awareness or visibility of the other non-conventional dispute resolution options. Next, please. This is a quote which our Chief Justice made some time ago in 2016. So our Chief Justice shared the above message at the 2016 Global Pound Conference, and I will quote, "An ideal system of justice is one that delivers justice that is customized to each type of case, keeping in mind the subject matter, the parties, and the desired outcomes. In this regard, it would perhaps be timely to embrace a paradigm shift and understand ADR not as alternative dispute resolution, but as a reference to appropriate dispute resolution instead." End quote. So the point is not to relegate ADR as an inferior option to litigation. At the end of the day, all the dispute resolution options are simply tools in the toolbox which enlarge our choices and options to choose a dispute resolution option which is best suited for the IP dispute at hand. Next, please. I will now share about our local ADR service providers. And the first one is, of course, the Singapore International Arbitration Centre. And as mentioned by our Chief Executive just now, SIAC has been recognized as the second top arbitral institution in the world. And again, we highlight that SIAC has a specialist panel of 26 international IP arbitrators, including the Right Honourable Professor Sir Robin Jacob, and of course, David, our very own panelist and speaker here. Next, please. Next is the Singapore International Mediation Centre, or SIMC. Now, SIMC offers Up Meet Up in conjunction with SIAC which is useful for enforcement. And again, as mentioned just now by our Chief Executive, SRMC has recently collaborated with WIPO, or the World Intellectual Property Organization, to manage IP disputes. Next, please. Apart from supporting, of course, our local entities, we also welcome top international dispute resolution institutions. So again, as mentioned by our Chief Executive just now, WIPO Center Singapore office is the only office outside Geneva. And of course, that is not all. Next slide, please. We are also pleased to say that the American Arbitration Association International Center for Dispute Resolution also has a presence in Singapore. In addition to the service providers, there's also a need to ensure optimal structure, and this encompasses both the hardware or the physical infrastructure and the software or the full suite of supporting services. An embodiment of this can be found in Maxwell Chambers. Next, please. I will now share some of IPOS's offerings to encourage mediation. Currently, we offer funding for parties to attend mediation of their disputes before IPOS. The amount can be up to Sing dollars 12,000 per case. That is Sing dollars 6,000 per party, where there are foreign IP rights involved. The point is to encourage parties to try out mediation and experience its effectiveness for themselves. The scheme is intended to encourage a mindset change. To complete the story, mediation and the EMPS, or the funding scheme, is broached at the first instance right after the close of pleadings. The reason why mediation is broached at an early stage is because at this point in the contentious proceedings, parties have yet to expend any cost to prepare evidence. However, we also understand that sometimes it may help the decision-making process if parties are able to assess the strength of their respective case. Therefore, we also broach mediation again, the second time, at the pre-hearing review stage, which is the stage just before a full hearing. At this stage, parties would have had sight of each other's evidence and would have a better sense of the strength of their respective case. Therefore, even if a hearing date has been set, parties are free to opt for mediation as long as the case has not been heard. So you can see that we weave in mediation at various stages of the contentious proceedings in order to encourage the uptake of mediation by the parties. Next slide, please. And yes, we have several success stories under the scheme. I will now share our first success case. Both parties were foreign parties, one from the US and the other from Thailand. Parties managed to not only resolve the dispute before IPOS, but also achieve global resolution covering in total 6 jurisdictions, namely the US, and then Thailand, Singapore, Vietnam, Malaysia, and Indonesia. And this was achieved in total about 20 hours. The cost, which amounted to about Sing dollars 11,400 between two parties, were totally subsidized by our funding scheme. In fact, there were some leftover funds to partially defray mediation-related lawyer fees and disbursements. And just a note at this point that it is actually possible to have mediation conducted via video conference. And in this regard, we also had a successful case example. In a dispute between a UK and Singapore party, a global resolution was also achieved by means of a one-day mediation conducted via video conference. Specifically, the UK party did not have to fly all the way to Singapore, saving much time and cost. Next slide, please. Thank you. This next and last example is actually the very first case that went for mediation. A Singaporean construction company filed oppositions against 3 trademark applications owned by 3 commercially related entities based in Singapore, Malaysia, and Indonesia. All the outstanding proceedings were resolved on a global basis again, and all it took was 1 day of mediation, and the matter was settled within 4 months. after commencement of the mediation. And this was particularly remarkable because parties had been in dispute for 20 years. Notably, the mediator was able to bring parties closer by using Bahasa Indonesia with the Indonesian party during private caucus to build trust. Therefore, one of the advantages of mediation is that parties can choose a mediator who is not only well-versed in the relevant IP field, but also familiar with the relevant languages and cultures. Next slide, please. Of course, we choose to strive to improve the uptake of ADR for IP disputes. I will now highlight some aspects of our Singapore IP Strategy 2030, which is Singapore's IP blueprint for the next 10 years in the area of ADR. Next slide, please. The two main objectives of SIPS 2030 are in the slide. For the purposes of my session today, we focus on the aim to grow Singapore as a global hub for intellectual property activities and transactions. Next slide, please. In turn, there are three interrelated thrusts to support your objectives. One of them is to strengthen Singapore's position as an intellectual property hub. This translates into, amongst others, positioning Singapore as a choice venue for international IP dispute resolution. Next one, please. Some of the initiatives have already been mentioned above, and I will only highlight a few here. In tandem with supporting our local service providers, and as mentioned by our Chief Executive, we also have the Singapore International Commercial Court, which has a distinguished panel of international judges, including some who has special interest in IP. And of course, as mentioned by our Chief Executive, the SICC has jurisdiction to hear IP dispute if it is an international in personam IP dispute. Other initiatives include, one, ensuring business-friendly legislation. So, for example, our arbitration legislation was amended to clarify that the subject matter of an IPR dispute is capable of settlement by arbitration as between parties. Number two, building thought leadership in the area of international dispute resolution. And one example is the Singapore Convention on Mediation, which eases the enforcement of cross-border mediation settlements. Last but certainly not least, we also seek to build IP dispute resolution capabilities by working with law schools as well as professional service providers. In this regard, we believe it is of utmost importance to inculcate the importance of ADR to law students who would be the future lawyers. That's all I have for today. I hope you have found the session informative and interesting. Thank you very much for your attention. Thanks, Daryl.
We'll transition into a time of panel discussion. I think our panelists are still here. Good. David, Holderman, Kiara, and Akko. All right. I'm going to start with a question each for you, Sandy, and Kiara, and you can decide who wants to go first. So one is neutrality. How does WIPO or IPOS guarantee neutrality in this process and the services that it offers? And the second is a cooperation with the courts. I think this particular is for Sandy. How does the court system work in tandem with the ADR dispute resolution system in Singapore? Can courts order mediation?
Kiara, do you want to start first or?
Sure, happy to. So when it comes to neutrality, that's really one of the advantages of the WIPO Arbitration and Mediation Center. The way we guarantee neutrality, well, of course, we are ourselves a neutral dispute resolution forum without having any link to any jurisdiction. And it's also something which is reflected, for example, in our rules. So if you read our rules, for example, when it comes to evidence, you see they were really drafted building on both civil law and common law traditions, so to make really this suitable these rules suitable for any type of dispute. And of course, neutrality is also very important in the moment of the selection and appointment of a mediator or an arbitrator or an expert. So that's also something that we take into account when it comes to nationality, geographical location, and again, that's something that in international disputes specifically is very often of the essence, and is one of the advantages of using a procedure like mediation or arbitration instead of a national court.
Thanks, Kiara. Sandy?
Although we are called the Hearings and Mediation Department, we don't conduct mediation. So we outsource mediation to mediation service providers, including the WIPO ADR and AMC Center. So what I understand from Kiara is that parties will be given the list of mediators to choose, and in the event that they can't come to an agreement or understanding, then WIPO AMC actually has rules to assist them to appoint a suitable mediator. That would be right, Kiara?
That's correct. So basically what we do is we provide some options, some candidates to the parties based on their preferences. And then we always invite parties first, if they can, to actually agree on one of the candidates. If they cannot agree on one of the candidates, then we ask them to rank them. And then we measure rankings and based on a number of considerations, of course, neutrality is a very important one. Then we appoint an arbitrator, a mediator, or an expert.
Okay, thanks. Russell, go ahead, Sandy. It looks like you want to say something.
No, so you asked me about the question about the interplay of the courts and the ADR system in Singapore.
Yeah, go ahead.
Okay, so in Singapore, the state courts have a presumption of ADR, but that simply means that there will be mandatory referral to consider ADR. Parties can still choose to opt out of ADR. However, if the reason is unreasonable for them to opt out, then there is possible consequences under the discretion of the court. Similarly, that's in the state courts. In the Supreme Court, the lawyers have a professional duty to advise about the viability of ADR. And again, any behavior or conduct will be taken into account in cost considerations. So it is sort of inbuilt into the court system.
Okay, great. I want to give folks, Judge Holderman, David, Marco, a chance just to respond to everything we have heard. And I see already a couple of questions there in the Q&A box. So thank you for those questions. We'll get to those questions in a minute. But Judge Holderman, do you want to say something?
Yes, I appreciate the opportunity to comment on this. I frankly applaud the efforts of WIPO and the Singapore office for the purpose of advancing ADR and advancing mediation. Frankly, it is very important, I believe, that we have customized resolutions. That's why, although there are a number of systems that you have to encourage mediation or arbitration, frankly, it is up to the parties to choose the mediator, to choose the mechanism by which they want to move forward to resolve their dispute in an appropriate way. I especially appreciate Chief Justice Menon's comment about it shouldn't be alternative dispute resolution. It should be appropriate dispute resolution, one that is geared toward the parties' needs and requirements. And so I think that is very important. I'll turn it back over to you, Dale. Those are my initial comments. Although I have to say, I'm right now in the middle of an email mediation, so I may be a little distracted at the moment, but I will move forward.
All right, thanks. David or Marco, do you have anything to add?
You want to go first, Marco? No? Okay. I have been appointed to do 2 WIPO mediations. And I have to say that the first one failed. So I was on the wrong side of the percentages. However, as a result of that mediation, they did settle about a month later. And about 3 years later, the same parties were in dispute again in the US, and they came back to me. So they were gluttons for punishment. I would just make a couple of points, if I may, Daryl. We've just had a Civil Justice Council review in the United Kingdom, published in June this year, which has recommended giving the court power to mandate mediation, early neutral evaluation, etc. And this is quite a step forward, because for the last 10 years or so, the English courts have held they had no such jurisdiction, because to order mediation would be to deprive people, deprive litigants of the right to a fair trial within a reasonable period, which is one of the conditions of the EU Charter of Fundamental Rights and the European Convention on Human Rights. So it'll be interesting to see if that is taken forward by the English courts. We also in Europe, and I speak for the former 28th member state of the EU, there is a mediation directive dating from 2008. I don't believe it's been used much, if at all, in relation to patent disputes. And in 2013, there was a report on the implementation of that directive, which recommended against national courts in the 27 European member states from mandating mediation. So the UK is a bit out of step with that. And then finally, we have the Unified Patent Court, which is an attempt to have a patent court of first instance in the European member states. That provides for a mediation center or mediation centers in Lisbon, in Portugal, and Ljubljana in what I call the former Yugoslavia. And the following recent dismissal of complaints before the German Constitutional Court, that the Unified Patent Court regulation was contrary to German law, it's now believed that the Unified Patent Court will begin operating in 2022, or more likely 2023, which is about 40 years after the first idea of having a unified European Patent Court. So it takes a bit of time to make progress.
All right, thanks, David. Yeah. Marco, do you have anything to add?
Hi, everyone. This is Marco speaking. Sorry that I just can't get the audio access due to some tech issues. I'm very pleased and glad to have this chance to talk about something about the IDR and IP. Personally speaking, it's true that we don't have too many IDR experience, but according to what we have witnessed in the industry, we believe that the ADR might be used by parties, the industry players in different scenarios. Personally, I think there may be 3 main scenarios. First, there might be a dispute between parties about the execution of a signed agreement, right? And then the second scenario will be like the parties fails to reach agreement during the negotiation. So they want somebody to help them to find a solution. And the third is that the parties maybe, still fail to find a solution after trying every kind of efforts. So they move to litigation. And during the litigation, they want to have the mediator to help them. So in these different scenarios, according to my understanding, we believe that the biggest challenge heading ours is how to get people to agree to choose ADR as a solution, the consensus, right? That is legal base to get a mediator or arbitrator involved. And I don't believe, honestly speaking, that in every case that people can find the consensus to move to mediation or arbitration. And in that kind of situation, all the advantages of arbitration might be harm arbitration itself, because not everyone really wants a very quick, professional, and binding solution through arbitration. So that is what I have been witnessed during the legal practice and the business practice. In short words, I do believe that the biggest challenge for parties or for all the elements of this the circle is how to help the parties to get the consistency to move to ADR. Oh, thanks.
Thanks, Marco. I think that's a great segue actually to transition into just broader consideration that Marco and a number of you had laid out for us. That's the elephant in the room. How do we encourage people to get into the room and talk to each other either through mediation or agree on an arbitral panel so that they can resolve these types of disputes through arbitration? One obstacle possibly is power imbalance. If you are a big company, you have little incentive to do that. You just bulldoze your way through the court system. But is there something which stakeholders can do, whether you're talking about the government or you're talking about industry or even practice, to encourage that? And what are the circumstances in which it might be helpful? Judge Holderman?
Well, I think, again, it's important to encourage them by allowing them to see the benefits of mediation or arbitration if they've agreed to it. Of course, arbitration it's necessary that there be an arbitration agreement in their contract, or the parties agree to it at the moment when the dispute arises. But with regard to mediation, there are so many benefits that come from that most commercial organizations look for. The first one is certainty. If you stay with the court system, you don't know what the outcome's going to be. You don't know if the judge will make a mistake, or the judges will make a mistake, or the appellate court will and disagree with you. But if you mediate, you will obtain the certainty that comes from your contract. And of course, as we've learned now with the Singapore Convention, once it's fully implemented, it will be enforceable throughout those countries that agree to it in their courts. But I think cost is another factor. If you're right, in the David versus Goliath circumstance, if the Goliath wants to bulldoze through the court system, that's up to them, and there's really nothing we can do at that point. But if cost is a factor, which it usually is, then mediation should be the preferable mechanism by which you resolve things.
Thanks, Judge Holderman. Yes, David.
Okay, I only add a couple of things. I think there's really nothing to be lost by mediation. What is the downside for parties? It's something which will only take a few weeks. It's not going to delay the court process overly. It's moderate cost. And even if it doesn't produce an overall settlement, it may reduce the outstanding issues to take forward. The other thing about it is that it's just not a one-shot procedure. One can mediate at any stage and on several occasions as a litigation progresses. For example, after the case management conference, maybe after disclosure of documents, after discovery, when more issues are on the table, maybe after expert witness statements, and even after judgment at first instance and pending appeal. Was always an opportunity to reach agreement through mediation.
Thank you. Okay. I know we've got questions from the audience. So one of them is from Chiara. In fact, we're going to be talking quite a bit about standard essential patents and the role of FRAND, the role of ADR and WIPO in that. I see a question also for Sandy, I think. The question, and maybe we'll take that one first. I think that's the one that's quicker to respond to. Can I apply mediation in Singapore, mediation center from Turkey, regarding an IP dispute that contains an EU community trademark? Is there any obstacle or limiting factor? Sandy?
I think it's not an obstacle provided that parties agree on the parameters of the mediation. That's the flexibility of mediation, right? So you can agree as to the scope of the mediation. So the short answer is no, I don't think it's an obstacle provided that you agree as to the scope.
Okay, thank you. And Chiara, do you want to lead us off on our brave foray into standard international patents? What is the role of WIPO as being the venue for resolving these disputes? You're muted, Chiara.
Thank you for raising this, and then absolutely this is one of the sectors WIPO really specializes in the area of arbitration mediation, and because we think that it's an area where court litigation may not always be the best option. So we've actually even revised our general ADR framework to make it more fit to these types of dispute. And that's where, for example, we have developed this guidance on ADR for FRAND disputes. And there really the benefits are mainly from the confidentiality, or also we make available some suggested mediation timeframes and schedule that parties can apply, some specific model clauses, submissions agreements that party can use. And for example, something that we do, and we feel that particularly in a sector like FRAND, standardization patents, is particularly important, is that we also have developed a panel of mediators, arbitrators, experts with expertise in that specific area. And more generally, it's also the flexibility of ADR mechanisms like mediation and arbitration that can bring a lot of advantages.
Thanks, Chiara. Now, I want to invite Judge Holderman and David to weigh in on this momentarily. And I think especially Judge Holderman, who has had the opportunity to really see this process from both sides, from the judicial side, where if you have not read his judgment in Innovatio, I recommend it. It's still cited today and still provides insights on how we approach these issues. But now having that moved on to the other side, the ADR side of things, he sees, I think, parties' business intentions maybe more transparently than on the other side of the bench. And also in the bigger context of things, since we're thinking about this internationally, the rash of anti-suit injunctions and anti-suit injunctions that we see going around the world, that's been precipitated, I think, by a few courts who are quite eager to weigh in on global static rate setting. So give us a sense of how ADR plays into these bigger dynamics. Judge Holderman, David, and the rest of you too, after that, if you'd like to weigh in.
Yeah, I'll be brief because I believe a number of other people have very pertinent comments to make. But you're right, I did have the opportunity to preside over actually more than one standard essential patent litigation. And there, fortunately, the lawyers were agreeable to moving directly without considering or making a determination on infringement, moving directly to the analysis for damages. And that assisted the settlement. In the Chicago federal court system, we have magistrate judges. They're appointed by the court, and their primary duty is to assist in the settlement process. And although I didn't communicate with my magistrate judge while I was presiding over the case, I encouraged them, the parties, to continue their settlement discussions. And so, yes, we weren't able to settle the case, so I did have to go ahead and issue a judgment on that. But ultimately, the parties did settle the matter. Now, on the other side, I have a good understanding in having mediated standard essential patent disputes. I have a good understanding of the parties' thought process. And of course, the main objective of each side is to get the best possible deal the other side will agree to. And that's why I, as a private mediator, I believe that's the approach that the private mediator should take, to assist each side in that endeavor. And once you're into the mediation process and moving back and forth between the rooms through what I call the shuttle diplomacy process, ultimately you will be able to reach a settlement that allows each side to get the best possible deal the other side will agree to. And so that's why I really do believe that mediation assists and enhances the determinations with regard to standard essential patents. Just briefly, since you did comment on the anti-suit litigation, that continues to, in my opinion, be a problem. The main case in the United States recently was Ericsson versus Samsung, which was all the way for the federal or to the federal circuit for a determination, and the parties had briefed the matter. But then the parties got good sense and decided we should settle this through a more appropriate dispute resolution process, and they did. So we don't have the federal circuit weighing in on it, but we do have a number of district courts weighing in on the anti-injunction matters. So those are my comments for now, but I await the comments of others.
Thanks, Judge Holderman. David? Okay, well, while waiting, Marco, do you have any thoughts from China? No, okay, then back to you, David.
Okay, just a couple of comments on mediation of standard essential patents. The ETSI IPR policy does have a recommendation that parties should engage in discussions with a view to settlement, but I'm told by the legal director at ETSI, Christian Loyot, that this has not been used. In an earlier webinar on this, which I moderated for WIPO, the in-house counsel for Nokia expressed the view that where the parties are relatively close to settlement, mediation can work. My own view is that with the big players like the Ericssons and the Samsungs, they know each other so well. When they've been through the court procedures that they went through in that case of anti-suit injunctions in both Wuhan in China and in Texas, that they decided to settle. However, I do think if you look forward into the different stakeholders who are going to be involved with standard essential patent FRAND disputes, with 5G and the Internet of Things, it's not always going to be these big telecoms companies. It's going to involve potentially a lot of small and medium-sized entities. And I would have thought that mediation would be extremely effective for them, rather than getting themselves sucked into international litigation.
Right, thanks, David.
So can you hear me?
Yes, Marco, we can hear you. Please go ahead.
Oh yeah. I was trying to say that in fact the ADR is quite encouraged in China as an alternative solution for litigation. In fact, we already have some specialized ADR court is even specialized in the IP fields in different provinces and cities like Shanghai, Guangzhou, Shenzhen. Even in some very large provinces, Heilongjiang, they have specialized IP ADR court or tribunal. But according to my experience, most of the cases are related to the trademarks, copyright, agreement issues. Not, at least I haven't seen any cases. Maybe it's confidential, but I haven't seen any public cases about the licensing discussion or patent infringement that is solved by our arbitration. But the mediation is very common used here in China in every kind of the civil litigations, because the judges will always ask parties if they want to mediate or keep their settlement discussion during the litigation. According to our experience, no matter as a patent holder, licensor or licensee, we do believe that mediation, even during a litigation, it will be very useful, because that will give parties a chance to find a flexible solution and with relative lower cost. And so I think that is something more easier be used by the parties than the arbitration.
Thanks, Marco. I have a couple of follow-up questions for you. It's interesting that we see that it seems like in China, there's greater success in getting people to mediate, perhaps by default. And the lawyers also seem to be more willing to say, we'll terminate this case early, let's mediate, find a resolution. Now, you are in an international company, so give us an international perspective. Is this, you think, a cultural issue? That is this a legal structure issue? What is it that you think sees China as having been more successful in this than some other places?
Yeah, it's just my personal views on this. I think I cannot represent the company or the other parties or the whole, the nation. The nation is so big to see this. But it's true that there is a tradition in China, I think, to mediate the disputes. Even in the past, in the society or in the old days of China, there's old sayings saying that the most important thing is to keep calm and keep harmony. And people feel shame to bring the dispute to a court or to a litigation. So the people want to talk with each other to find a solution. And no matter, so in a modern legal society, no matter arbitration or no matter mediation, give a chance to people to sit down to find a way, right? In a friendly manner, amicable manner, to find a flexible solution. parties. So in a cultural, perspective, I believe that will help people to choose ADR. But if we move this deeply in a commercial world, and then I think the decision makers might treat things in a more economical way. The decision makers may weigh the income, the outcome of a solution, of a potential solution, and they have different ways in the decision-making process. So that's the reason why at the beginning saying that in a different scenario, especially in a scenario that people, just in patent license discussion, when the parties fail to negotiate, to find a way through negotiation, the licensee side may not want to the arbitration involved or introduce the solution, because arbitration, we know that it's more quicker and more it has a very quick process, and you don't have to mark you don't have a chance for the second instance as a remedy.
Thanks, Marco. Yeah, one final follow-up question before we give folks on the panel a chance to respond is, when you are in an international company dealing with international opposing sides, having to deal with various jurisdictions, what goes into your mind in deciding, okay, am I going to mediate or arbitrate with this company or mediate arbitrate in this country? Tell us from a business perspective how you advise your company on these things.
It's a very good question. In fact, it's very it's a difficult, it's complicated thing, that there are different matters and factors that you have been keeping in your mind. I think first it is the cost, of course, is very important, and if it is a neutral, right? Because you need to make sure that there is any prejudice in the solution manner. And then it's also important that to say, if you understand the legal system or the governing norm of the ADR or the jurisdiction you are going to choose, and also the local culture, the local legal system, it's also plays a very important role, that because nobody wants to get their disputes governed by an underdeveloped law, or there is not experienced legal services, lawyers, accountants, arbitrators, mediators. So you need to think all things together to make this decision or make your advice to your top management.
And in practical terms, then, when you look at New York or London or Singapore or WIPO for that matter, have you used any of these places, and what are your experiences as a user?
Well, I cannot tell too much about the confidential issues, but it's true that we have experience in those things, in those cities or those organizations or arbitration venues that you mentioned. We do have some kind of experience, and I have to say that among all of these, Singapore enjoys some kind of priority in some cases, because it's neutral, right? It's between China and the European or between US countries. And it has a very well developed legal system, and it's famous for the arbitration center. And they have a very good lawyers, arbitrators, mediators. You can find the kind of experts there, and not as more expensive as London or New York or Paris. I'm not advertising Singapore, but I just tell something that we have it in our swords.
All right, thanks. You can't see this, but Sandy is smiling very broadly, and I think you helped make her day today. Yes. Okay, David, you look like you have something to say. Please go ahead. Thanks, Marco. David?
Can I just jump in here? I think the problem is that standards are global and patents are territorial. So you're trying to get a global solution from one national court, which is limited, which has limited jurisdiction to the standard essential patents registered in that country. And the problem, I'm afraid, came from the United Kingdom in the Unwired Planet case, where the judge took global FRAND jurisdiction. And that has set every other national court, well, not every other, but certainly in China and in India, to do the same thing. So you get into a battle of anti-suit injunctions. And these national cases from an outsider, Marco, seem to be somewhat futile to me, because there is no international convention for enforcing the judgments of national courts. There is, however, for international arbitration. You have the New York Convention of 1958, which is, provides for recognition and enforcement in over 160 countries worldwide. Now, that has sparked off a paper from one of the British judges, Richard Arnold, who's a Court of Appeal judge, to suggest that what ETSI needs to do is to change its constitution to provide for mandatory arbitration. I think that's easier said than done, because that, I think, requires quite a substantial percentage in favor of the ETSI membership. And the ETSI membership includes a lot of originators and a great many implementers as well. And to get consensus, I think, would be difficult. What he envisages is a multinational tribunal, which he said should have special expertise. And he said this would give confidence to both patentees and implementers of all nations. I think it's a very laudable idea, but I have a couple of problems with it. First of all, multinational tribunals, in my experience, don't have a great success record. And specialist expertise is something which moves with time as we move from standard to standard. So my view is that if FRAND disputes were to be arbitrated, it would be much better done through the WIPO Arbitration Center, because after all, that offers total neutrality. WIPO is part of the United Nations system. And as far as having a multinational tribunal, I do believe that that the stakeholders would want to have the traditional method of each appointing their own arbitrator, and in default, the appointing authority to appoint a chairman who's not a national of either. And an experienced arbitration tribunal would certainly be able to deal with the technical issues which the parties' respective experts would give evidence about. So I'm in favor of Richard Arnold's proposal in general, but I see certain problems to it, and I've offered a solution which should please Chiara and Heike. And I should add very briefly in that WIPO have produced a guidance note on FRAND arbitrations. And Jim Holderman mentioned in his case, the INRI Innovatio Ventures, I think, that the parties didn't litigate validity and infringement of the patents, but went straight to FRAND terms. And what the WIPO guidance note has a draft submission agreement to arbitration, and that would give the parties the option of arguing and presenting evidence on validity and infringement and essentiality, all of which will affect the FRAND royalties, but not to ask the tribunal to make any decision, not to issue an award on validity, infringement, or essentiality. The other thing is that if essentiality is a stumbling block to begin with, in an arbitration, it can always be dealt with as a preliminary issue with an interim or partial award. And if you go that route, it may very well get the parties thinking, and you will find that they come to an agreement. And I would say from my experience as an international arbitrator of patent and other IP disputes, there's a fairly high instance of settlement at some stage in the case. In fact, I'm beginning to think that when I'm chosen as the arbitrator, that they think that anything would be better than getting an award from me, so they settle straight away. But I'll leave you with that thought.
That's certainly a negative incentive, which you could charge a premium for, David.
Yeah. If I can pop in on that.
I see Judge Holderman. Yes, go ahead. And then I would like Chiara to weigh in after you're done.
David's facetious remark, I'm sure that what the parties determined was that they evaluated the circumstances, and David encouraged the settlement and was able to resolve it. But I agree. It's an assessment of risks, and if there's a necessity for essentiality, and in Innovatio, I did have to make a determination. I used the mechanism of summary judgment with regard to essentiality, but made no determination on infringement or validity because, frankly, the party said no. We'll just consider the risk of what the circumstances are with regard to the potentiality of an adverse determination, and move forward to damages, which I would hope would be that would just be factored into the settlement process. At least that's been the experience I've had in the private sector dealing with standard essential patent mediations. One other point I just wanted to, I agree with David that it's standard essential patent mediation and standard essential patent litigation is going to move from the giant companies to those companies that provide services and approaches and elements of just about every device that we work with. Automobiles are becoming the major area where there's standard essential patent disputes coming up because the parts providers, the system providers are not the gargantuan companies. And so I do believe that it is very appropriate to try to work out a mechanism. And if the international organizations such as ETSI or IEEE work in a way that would be forward thinking to a settlement process, that would be beneficial. But those are my comments. But David, I know you. We worked together in the same, or we worked in the same organization, and you do an absolutely outstanding job, and we're proud to have you with us.
Now, since you brought this up, Judge Holderman and David, I just want to briefly focus on this issue of standard essential patents. You have both identified that as a possible means to move forward. At the same time, David, you talked about the impasse between implementers and patent holders. Is there really a way to break this impasse? Do they have to change their voting mechanism, for example? Or should this be something that's implemented in parallel to that, so that the law is there, the entire organization has to conform to the law?
Very difficult. I mean, in a conversation with Christian Loyot of ETSI, he felt that if he could get some movement on mediation, it would be a start. And in that respect, he felt it would be very helpful if both European patent judges and US patent judges were to support that approach. And I'd be interested to know from Jim whether in his court, his former court, you would direct parties to mediate at an early stage, as I gather is done in certain of the California courts, certainly in Northern California. It's also done in the Australian High Court. But to get the change necessary to implement Richard Arnold's mandatory arbitration proposal, I'm not sure how one goes about it. I mean, I think one needs support from international judiciary to say our hands are tied, we have limited jurisdiction, we can't carry on the way we are, issuing anti-suit injunctions. There's no point in issuing global FRAND licenses because we can't enforce them outside our own jurisdiction. So I think if one has support from international judiciary and maybe also from the regulators, both in Europe and in the US, that this is the way to go, that eventually ETSI members and those in the IEEE may see that some form of international arbitration really makes sense, as opposed to this deep pocket litigation in several countries at the same time, which, as I said before, I think is fairly futile.
Thanks.
I don't think I've answered your question, but I've certainly talked it through.
Judge Holderman, go ahead.
Yeah, well, I agree with David. Frankly, the courts of the United States, the judges of the United States typically encourage settlement at a very early stage. In fact, we do have, the federal courts have the power to order settlement conferences with the magistrate judges, but in my opinion, and there's a difference of opinion, I don't believe a judge can order private mediation, but a judge can certainly strongly encourage it. And I know that the judges of courts around the country do strongly encourage private mediation to allow the parties more opportunities for settlement than can be allowed by the time of the magistrate judge. But I also agree that frankly, if the standard setting organizations were to come up with an agreed upon mechanism that would allow the participating parties to reach a global resolution through an agreement, that would be best, because, as David said, the national courts do not have power to, in my opinion, I would have been interested to hear what the Federal Circuit said in the United States about that, but in my opinion, national courts do not have the power to enforce anything beyond their own jurisdiction unless the parties agree to that process.
Judge Holderman, before you mute yourself, just a quick follow-up. Now, in practical terms, what incentives or disincentives can the judge do to strongly encourage settlement?
Well, one of the things that the judge can do is make, in my opinion, make interim determinations on certain of the issues. And for example, as I mentioned in the Innovatio case, I made determinations with regard to essentiality, with regard to the family and the grouping of patents that were a part of the lawsuit. That assisted the lawyers in assessing further risks with regard to infringement determinations or validity determinations so that they could come to an agreement. That's one of the things. In fact, I always told my law clerks who assisted me in preparing opinions that we need to keep in mind that every opinion we write, every opinion that is issued, we should be trying to encourage the parties to reach a resolution beyond having a judgment entered by the court. And so those are some of the things the courts can do and do to try to assist the parties.
All right. Thanks very much. Yes, David.
Could I just add one other incentive which came from a real live case when I was still in practice before Robin Jacob, which subsequently became Lord Justice Jacob and was mentioned is on the IPOS IP list of arbitrators. It was it involved confectionery bars. I think it was one of the Mars bar products and a lookalike which had been made in Germany. And we had our first hearing for directions in front of Robin, and he looked at us and he said, "I think this is a case that ought to be settled. I strongly recommend you to mediate. Otherwise, neither of you might like the decision I make." So that was quite an incentive to go off and settle it, which we did.
Thanks, David. Yes, Judge Holderman.
That's what I'm talking about.
Okay.
That kind of approach, yes.
The case that proves the point. Wonderful. Yes. Now we have, go ahead, Chiara. Well, there are two things I think which David raised in his earlier remarks, spotlighting the WIPO ADR process, which I think people would be interested to hear your thoughts on. The first is, why aren't more people using it? It's there. The UN is a ready-made global organization, and WIPO is a global organization, and WIPO ADR is a vehicle that's there ready as the expertise to resolve these issues. Is it awareness? People are not aware of it. Is it cost or some other concerns? What goes through your mind and the mind of your colleagues in thinking, how do we make this work for the world?
Well, it's very broad. I think, first of all, is raising awareness. There's still a lot of work to do in that sense. And for that, of course, we partner with firms, with companies, but also with stakeholders such as, for example, intellectual property offices and courts. And I think that they really play a crucial role. So, for example, what we do in Singapore, this collaboration with IPOS, we also have in more than 70 countries now. So we collaborate with the IP offices of this country, and we have very different collaborations depending on the country. All of them include raising awareness. And then with some of them, such as IPOS, we also have some specific mediation options. But basically, the IP office helps us promote among the users of the IP office services, arbitration and mediation, specifically mediation. And it's also quite interesting, some of the collaborations that we are developing and we have developed with courts. Also, courts help us promote, in particular, mediation, including in the context of pending court proceedings. So, for example, we collaborate with the Patent Regional Court in Munich, in Germany, but also in China, we collaborate with the Supreme Court of China. So in some courts, for example, in Shanghai, the courts actually give parties the option, the opportunity to refer the cases before the courts to WIPO mediation. And this is a very recent development, already the last years, and we've seen that it had a lot of success. We've seen many cases. Some of them were trademark related cases, some of them were patent cases, all of them were international cases. cases, and that's where I also think that the neutrality was also a good advantage for both parties. So we've seen quite a few cases, and for that we've also trained some mediators. We have special fees, but certainly the support from stakeholders like IP offices, the courts, some ministries really goes a long way. And then one of the obstacles, I think, is that sometimes there is no IP dispute resolution policy. So that's why we insist so much on drafting clauses. That's why the guidance on FRAND is an example, and it's a very good one. But also in other sectors, and generally, we provide and we really encourage parties to use ADR clauses if they have a collaboration in their contract. Then of course, where there is no collaboration, or even if there is, but there is no reference to mediation arbitration, they can still submit any dispute to WIPO mediation, WIPO arbitration, but the earlier the better. So we always encourage parties to take into account and consider including dispute resolution clause providing for mediation and arbitration. And specifically the combination of the two that we see very often used. For example, we see in many cases mediation followed by expedited arbitration, which is a sort of fast track arbitration, which can be very effective because they basically combine the two options. And in an event mediation, there is very little risk associated with the WIPO mediation, while its advantages can really go a long way. So these are just some of the obstacles. So we still have a lot of work to do, but raising awareness is definitely the first step.
Thanks, Chiara. I have a couple of follow-up questions for you, and I think Sandy can weigh in on them as well. But we have about 20-some minutes left. We have time for some questions, but we'll need your help, audience, to help us to determine which questions to ask the panelists. So please vote up, or I don't think you can vote down, but please vote up the questions that you are most interested in hearing from, so that we make sure that we get to those questions after that. Now, my question to you, Chiara and Sandy, is: do you feel like you are getting enough support? Chiara talked about support from IP officers, and Sandy is working in one of those IP officers, but there are others. Do you get enough support from the stakeholders in pushing forward ADR as a means of as a viable means of alternative dispute resolution, mediation, arbitration? And the second question is, we've been talking about patents, but of course IP is more than just patents. We've got designs, we've got trademarks, we've got copyright. Do you see more success in getting people to move towards mediation, arbitration, and other types of IP in trademarks, designs, even trade secrets, and copyright? Chiara and Sandy.
Certainly, although the majority of our cases still relates to patents, actually we've seen an increasing number of trademark-related disputes, and maybe one of the reasons for this is also these procedures in trademark proposition proceedings that we make available. So that's one, but also copyright, including digital copyright, is an area where we see more and more cases, and that's very, very interesting. The designs, we've always seen less cases. That's probably because also the volume of disputes. And then very often there are just this more, in a way, commercial cases related to software licenses, and IT, which we see also growing very, very fast. And trade secrets also increasing. So I would say that the case on patents is steady, but other types of IP are also increasing. An example, even it's a geographical indication. So, for example, also under our collaboration with IPOS, we also extended our WIPO mediation option to geographical indications, as well as also designs and copyright. So there is definitely more awareness also in other areas of intellectual property.
Okay, hold on. The second, since you are still on, Chiara, in terms of support from the IP officers nationally and national governments, what are they doing right and what can they do more?
There's always need for more support, but we have really some fantastic examples of support that we also try to showcase to other offices to see really what others are doing and how they could also benefit from promoting mediation arbitration. For example, the collaboration with IPOS is one of the ones that we always showcase, and that's because really IPOS is incredibly proactive in promoting ADR options. But also, for example, in training mediators. So Sandy, maybe you can mention that as well, but the IPOS has a lot of initiatives in training young IP mediators. And also in terms of funding, under certain circumstances, the cost of the mediation can be funded by IPOS. We also see a similar scheme in the Republic of Korea, and also, for example, in Poland, in Europe. And of course, this is a great support coming from the office because it financially helps parties recover from the cost. But at the same time, we have really many collaborations at all different stages, and it's also important to adapt the collaboration to the degree of understanding and also needs in terms of ADR of the specific country and jurisdictions. So in a way, there is no one size fits all, but you always try to fit and adjust the collaboration depending really on the needs of the IP office and the country.
All right, thanks. Sandy, I almost feel like you don't have to say anything at this point. David has been praising Singapore, Kiara has been praising Singapore. It's like just like what they said, but we'll give you a chance to respond yourself. What do you have to say?
Okay, in terms of stakeholders, I think over the years, at least in Singapore, we have seen mediation is gaining traction slowly but steadily. So we have definitely the lawyers, the IP lawyers that we deal with. Not all has bought in yet, but definitely more and more of them are buying into ADR and mediation. And I think this is due to a lot of a big reason is because the huge buy-in from the judiciary. So as you can see just now, the quote that I used is from our Chief Justice. In fact, in the recent India-Singapore mediation summit, the Chief Justice, again, he actually said to the effect that access to justice can be achieved outside of adjudication, outside the courtroom. So the buy-in from the top is very important. The judges, from the Chief Justice to all the judges, it helps in so the support from the judiciary is very strong. The lawyers were gaining ground, and the academia as well. As Kiara said, we collaborate with the universities, with the lecturers in the universities in Singapore very closely. So our program, like we have the Young IP Mediators Initiative under our office. It's due to a huge part of it is due to our strong collaboration with the university professors. And recently, as I shared in our slide, we actually introduced IP into some ADR courses in the tertiary education. So we definitely have a lot of support, and the legal profession, it's increasing, the support is increasing. So hopefully in days to come, I always say before I retire from this profession, I can see wholesome support from the legal profession. Thanks, Daryl.
Thanks, Sandy. Now, to use a FRAND term, there's the top-down approach and there's the bottom-up approach. And it looks like Singapore is doing both. You have the judges, the Chief Justice himself saying, yes, do this. But also you're reaching out to law students even before they become lawyers and saying, this is a normal thing to do. This is a good thing to consider. And I think that may be one thing, just to allude to a point that Kiara made earlier, that set Singapore apart. It's small enough to do it. You are cohesive enough to do it. And you think not just in 2-year election cycles, but decades ahead. And I think that certainly helps the process. Now, as I promised, I'm going to get to the questions. I see one from Aditya. Aditya has a question that goes as follows. Pursuing my PhD on this topic, role of our WIPO dispute resolution mechanisms in IP disputes. So, Chiara is the perfect person for this. My question is, what is the success rate of solving IP disputes through ADR mechanism?
So for WIPO, the settlement rate for mediation is 70%. So 7 cases out of 10 parties settle. Last year, in 2020, that was 78%, so close to 80, and that's for mediation. In arbitration, the success rate is 33%. I have to say that when in mediation, the objective of the parties is to settle. In arbitration, that's not necessarily the case. The parties are normally looking for a favorable award from the arbitrator or arbitrators. But even then, even if that's not the default, even in arbitration, parties have the opportunity to settle, and we see that in more than 30% of our cases, they find some room for settlement, even in the arbitration case.
Thank you. We'll just take one more before we move back to the panel discussion. What are the key challenges in your view of the use of mediation for resolving specifically IP disputes? I think we did touch on this, but does anybody have anything further to add on this billion-dollar question?
Quickly, I provided as part of the program materials the 10 top tips to make your intellectual property mediation success. And frankly, I think the main impediment is the mindset that people come to, if parties come to a mediation with a litigation mindset, expecting to beat the other side down, it won't be a success. It's necessary that the parties come to a mediation with the mindset that there needs to be compromise. There needs to be a conciliation to some extent, where you will obtain benefits that are greater than those you give up. That's the approach, but you have to give up some of the benefits to gain the benefits of a resolution. So I frankly think that's the main impediment, people coming to the mediation process with the proper mindset.
Thanks, Judge Holderman. David, did you have something to say? No, okay. We can always come back, no problem. Yes.
Did you want something from me on that? Okay, I'm sorry.
Only if you did.
No. I would, in getting people to mediate, I'm just sort of switch to mediation and arbitration, because what I've noticed from a big change from my days in practice as a litigator, which ended in 2013, and now, and I see that management of multinational entities who in the past would let the deep pocket parties litigate in several jurisdictions around the world. These days, they don't want to do that. They want certainty in a reasonable time, and they want one dispute, preferably with no appeal, and appeals in arbitrations are the exception rather than the rule. The other thing with patents is arbitrators only have jurisdiction to deal with validity inter partes, i.e. between the two parties. It's not public, it's not erga omnes. So another advantage is that if your patent is held invalid, it's not open to the rest of the world to let in other competitors. So it's a huge advantage to use the ADR system, be it mediation, which is totally confidential, or arbitration, which is generally confidential. The only other thing I'd add to Judge Holderman's tips on mediation is that I think it's incredibly important for the mediator to hold separate meetings with parties beforehand. They get to know him, he gets to know them, and you can eliminate an awful lot of issues by having those meetings, and also speed up the day of the eventual mediation meeting. So I can't emphasize that too much. I was in a big mediation of a patent dispute relating to disputed ownership of a monoclonal antibody for the treatment of colorectal cancer. And we had litigation in the district court in New York. It was going up to the Federal Circuit. We'd been on a preliminary point to the UK Supreme Court. We were in Munich, we were in Vienna, we were in Paris, and we were in Amsterdam. So it was a colossal dispute over $1 billion a year drug. And eventually the parties said there must be a better way. So we had a mediation. And when you talk about incentives for mediations, the place of mediation can often be important. So they chose Paris, and everyone says, oh, okay, we'll go to Paris. The mediation took 3 days. It didn't produce settlement, but it got the parties talking. And within several weeks afterwards, there was a global settlement of litigation which had cost multi-millions over 4 or 5 years. That's the end of my homily on that.
That you actually raised a very interesting point, David, and one that I'm going to bring us back to after that as well. Now, you talk about the advantage erga omnes versus, between the parties, inter partes versus at large. When the mediator or the arbitrator looks at the patent and says, okay, this really is not a valid patent, or it's not a fringe, or it's not essential, and they make that determination. Just so folks, especially those who are not familiar with the patent scene is concerned, it's just between the parties. In fact, the patent is not declared invalid, but it's treated as such for the purposes of the mediation or the arbitration. Is that what you meant to say?
Sorry, can you just repeat the last bit of the question, Daryl?
The patent is still valid. It's, as far as the rest of the world is concerned, it's valid. It's maybe essential, but as far as the mediation is concerned, as far as the arbitration is concerned, when they talk about what the FRAND rate might be, it's considered invalid or not essential. I didn't think it was a difficult question.
I'm going to defer to Jim on it, actually.
I think David actually, well, first of all, the answer I believe is yes. That because of the privacy of the arbitration process, that if the parties agree they're going to accept for purposes of the this arbitration, the finding of the arbitrator on this point, it still allows them to argue, for example, if there's a determination of invalidity, it still allows them to argue the validity of their patents in other fora. So yeah,
well,
I think that's one of the advantages.
Well, what is the incentive for the parties to be frank in disclosing these things in hope of reaching settlement if there is the real specter of litigation that could happen immediately afterwards? What do you tell parties that come before you? Be frank, but not too frank?
Well, first of all, there is a mediation privilege, so nothing that's said in the course of the mediation itself can be presented in evidence. But of course, the other side hears the comment. But that's where the real benefit of mediation is the shuttle diplomacy aspect, where one side can talk to me candidly. And this is, and I agree with David, that meeting with the parties in advance, if that's necessary to gain their trust, is appropriate and essential. But if the parties trust me to discuss with them the strategy of a particular point, I will not disclose the discussion to the other side. I will just disclose whatever proposal comes from that. And that is the benefit of mediation, where it allows you to consider, okay, let's assume there is a finding of invalidity on this point. Or what, not assume that there's a finding of invalidity. What are the probabilities that there will be a finding of invalidity? That's what we need to take into account when we make our proposal. Even though we don't tell the other side what our thinking is, we tell them what the proposal is. So that's my long-winded response.
No, that's helpful. David, go ahead.
I think in the case of a FRAND dispute, you know, a patent with certain claims may be held invalid in the UK and it may be upheld in Germany. So there's little point in getting really into it's going to be a factor in an arbitration which relates only to settling FRAND terms. It'll be a factor in a mediation as well. But just one point on mediation, which is a general point, which would apply also, I think, is that I've been involved in a couple of co-mediations. And in a big dispute, it's enormously helpful to have a co-mediator. As one person is listening, one person is looking for reactions from the parties. And when the can caucus together, two heads are better than one. And I had a particular one with a very experienced JAMS mediator. And it was, it involved litigation in a huge number of countries over trademarks. And he said to me, he said, David, what do you think the solution is? And I said, well, I think it's dead simple. It's this. He said, I agree with you. He said, the trick, though, is to make sure that you maneuver the parties into thinking of it themselves. Because if you put the solution forward, one of the lawyers is going to find something wrong with it. But if you can persuade the parties to do it, I see Jim smiling. Is that something you buy into?
You're giving away some of our trade secrets, David. So, of course, it has to be the parties' thought process. They have to own it, and you're right. That is a technique and the technique, major technique in mediation. But go ahead. That's why I was laughing. Go ahead. I didn't mean to interrupt.
Okay.
Thanks. I want to bring Chiara, Sandy, and Marco in the remaining few minutes that we have. But before that, let me ask a question from the audience for you, Judge Holderman. Yes, go ahead.
Okay.
You had something to say.
No, I was going to say I'm going to have to leave the meeting. You and I mentioned or talked about yesterday what my additional obligation was that I have to do. But I'm happy to respond to the question that you got.
Okay. This is from the audience. Question for Judge Holderman. Why would parties undergo private mediation when federal courts assign IP litigation to work through court mediators in the early stages of litigation?
Well, the benefit of private mediation is the private mediator can devote more time to the process. And as David said, sometimes these mediations don't settle in one day. In fact, they continue on. As I mentioned, I've got my iPhone here and I'm emailing back and forth on a mediation that's going on right now. I had it's a post-session mediation. But the benefit of a private mediation is, first of all, the mediator is, well, the former federal judge like myself, I can, in a caucus session, provide a candid evaluation of what I believe the outcome may be in the court, but do that in a private session with one side, so the other side doesn't become emboldened with at least my assessment of the process. I will always always consider that there is risk because, as I've often said, no matter how strong your case is, the judge may make a mistake. And at that point, you may have an adverse determination. And so that's why you need to consider the risk. But also, as was mentioned earlier, the certainty of the mediation process, the certainty of the mediation outcome, the immediacy. You decide that the case is decided now by the parties as opposed to years from now by the courts, and the cost. The cost is inconsequential when compared to the cost of major patent litigation in federal court.
Thanks. Wise words to leave us with. And thank you for joining us. No, please
I am
go ahead.
going to thank you very much, Daryl, and it was nice seeing my friends on the panel and some of you in the audience. And I even gained a new friend today that I was a law student back at the University of Chicago when I held a trial there for purposes of displaying how trials work. But in any event, I have to leave, and I appreciate the opportunity, and I apologize for this other obligation that was thrust upon me. So I thank you very much. Have a good day or have a good evening for the rest of you. Thank you again. I appreciate it. All right.
Thank you. Now, thank you. Just one closing thought from each of you.
Well, I really hope that the session was helpful to see mediation and arbitration as not necessarily the best mode of dispute resolution. I think there were also a few questions asking which one is the best, but to get people to start thinking of it as an option. Because then, of course, every case is different. It's very hard to know from the start, but to consider mediation, arbitration, a combination of those two as a real option to other dispute resolution mechanisms that they're more familiar with. The results have been phenomenal in our experiences. Again, it doesn't mean that it's the best solution for all cases, but it's definitely a very good solution for many of those. So I really hope this encourages parties to consider it in their next cases.
Thanks, Kiara. Sandy?
Can I just say I echo Kiara? But actually, that was what I had in mind. I think just to repeat the point that was, I hope it came across. Again, we're not saying litigation is bad, to put it bluntly. We are not saying it. We're just saying that do consider all the other dispute resolution options. There's a whole array of them, and consider what's best for the current dispute at hand. And that's one point. The other point is, I think as our Chief Justice said, it's like justice can be achieved outside the courtroom. So thank you very much.
Thank you. David? You're muted. You clicked twice.
When you look around and see the number of retired judges from the US and Europe who have become mediators, it is proof that there must be a better way than national court litigation. And as I said before, as far as mediation is concerned, I think there is everything to gain and very little to lose by doing it. But it is something, I'm afraid, that a lot of litigation practitioners are not yet sufficiently tuned into. It's getting better, but there's a long way to go.
Yes, that's why we have this, and that's why your presence, all of you here, are important. And the last word goes to you, Marco.
Thanks. As someone from the industrial player, I have to say that it's always welcome to have a quick, reasonable, fair, and non-expensive solution to find a way to solve the dispute, no matter it is a licensing dispute or infringement dispute. So we do welcome and appreciate all kinds of efforts from the judges arbitrators and mediators in different mediation or organizations. We do appreciate this kind of efforts and would like to contribute to share our views on this point. Thanks.
Thank you, and you've done so magnificently despite the technical challenges. So thank you for participating with us. So with that, I would say at this point, please join me in thanking the panel. I know you are, wherever you are doing so. Actually, you can put a thumbs up. I'm going to put a thumbs up and I'm going to put an applause. I think that's how you can now show, like on Facebook Live, these things. You can see a lot of thumbs up and applause. So there you go. That's for you, panel. Thank you all very much for joining us.